10 mistakes people make during litigation. Today we are talking about a topic that could make or break your case. The 10 biggest mistakes people make during litigation and how you can avoid them. I've seen smart, well-prepared people lose strong cases, not because the law was against them, but because of these mistakes. So if you are in the middle of a legal fight, or think you might be, this video could save your time, money, and stress. Let's dive in. First mistake. Don't have a plan and not being clear about your goals. One of the most damaging mistakes is not knowing what you are trying to achieve. Sarah sued her business partner but never defined what success looked like. She changed her mind constantly. One week she wanted money, the next she wanted an apology. Her cases become messy until we took over the case and started to build up a consistent strategy. If you enter litigation without a clear plan, you are likely to panic as the process unfolds. Every motion, hearing, or negotiation will feel overwhelming because you don't know what success looks like. Ask yourself early on, what's my ideal outcome? What am I willing to compromise on? What's my minimum acceptable result? A clear litigation plan with defined objectives act as your compass throughout the entire process. Without it, you are navigating blind. Second mistake, underestimating the costs of litigation. Litigation costs money and more than you think. Tom filed a lawsuit expecting it could settle soon. 6 months later, he had spent $30,000 and was panicking. He had to accept a low settlement because he simply couldn't afford to keep going. Lawsuits involve legal fees, filing costs, expert witnesses, and sometimes appeals. Many people start strong but run out of resources midway, forcing them into poor settlements or even abandon their case. So be realistic. Know how much you can afford. Discuss cost estimations and billing structures with your lawyers. Keep some funds reserved for unexpected developments. Without proper budgeting, even a strong case can collapse under financial pressure. So plan ahead. Discuss costs openly with your family and your legal team, and make sure the potential reward is worth the investment. Mistake number 3, hiding information from your lawyer. Here's a story I see too often. A client hides an embarrassing fact, hoping it never comes up. It always comes up, and when it does, the lawyer is caught off guard. The client's credibility collapses. Clients sometimes hide facts that they think are minor, embarrassing, or harmful, but if your lawyer doesn't know the full story, they can't prepare a proper defense. And if that hidden fact comes up in court, it's dreadful. Remember, in civil litigation, everything you tell your lawyer is confidential. The more they know, the better they can protect you. Mistake number 4, refusing to compromise or negotiate. One client told me, I want it all. I'm not settling for less. The problem? Evidence changed. The legal landscape shifted. Their all or nothing approach backfire, and they end up with nothing. Many people go into litigation believing they must win at all costs. That mindset often leads to disappointment. Litigation is dynamic. Evidence evolves, prospect changes, so should your expectations. Being unwilling to negotiate or compromise can result in worse outcomes, longer delays, and higher costs. Negotiation doesn't mean surrender. It's about being strategic. So adjust your expectations as the case progresses. Focus on outcomes that meet your core objectives. Seek advice from a lawyer about what's realistic. The most successful people in court are flexible, not stubborn. Compromise isn't weakness, and often, settlements achieve 90% of the goal with 10% of the stress. Mistake number 5, not willing to spend time and effort. Litigation isn't just your lawyer's job, it's yours too. You can't hand everything to your lawyer and walk away. You need to hold yourself accountable and hold your lawyer accountable. I once saw an opponent's witness got cross-examined. It became apparent to me that he didn't review the key documents or prepare for the cross-examination at all. On the stand, he contradicted himself. The judge noticed and heard the case. Take time to read everything, in particular your own witness statements and your opponent's witness statements. Check documents, track key dates, and prepare yourself before every court event. Preparation builds your confidence and credibility. For final hearing, cross-examination can be tough. If you are unprepared, it will show, and it can damage your credibility. Take ownership of your case. Invest time in understanding the details. Trust me, your involvement can make a real difference in the outcome. Mistake number 6, missing deadlines and being unresponsive. Delays kill momentum. Missed deadlines can cost your claims or evidence. One of my clients used to have a statement of claim ready, but didn't sign it until the statutory limit lapsed, which caused a lot of trouble and created barriers for us to overcome. Courts run a strict timetables. Missing even one deadline may have serious consequences, including dismissal of claims, contempt, or missed opportunities. And being unresponsive to your lawyer or the court's request delays the progress and limits your ability to present your best case. Respond quickly, stay engaged, notify others in advance if there are any expected delays. Mistake number 7, lacking patience. Many people expect quick results, but litigation is a marathon, not a sprint. Frustration leads to rushed decisions such as accepting a poor settlement or giving up entirely. Patience, on the other hand, allows your lawyer to build a strong case, negotiate better terms, and respond strategically. Accept that litigation takes time. Set realistic expectations from the start. The stronger cases are built over time, so be patient, trust the process, and think long-term. Mistake number 8, blaming the system and disrespecting the process. Some parties become bitter and start blaming the system, the law, the judge, even their own lawyers. Others ignore court orders to act disrespectfully. I've seen many examples where witnesses argue with the judge when they didn't like the question. That's foolish. That approach hurts your credibility and weakens your position. Judges notice attitudes and behaviors. Respect for the legal process, show maturity, and it can subtly influence how your case is received. Instead of fighting the system, learn how to work with it. Mistake number 9, breaching confidentiality and talking too much. One client lost the settlement advantage because they posted about the case on social media. The other side used it against them. Talking publicly about your case, online, to friends, or even to other parties is a major mistake. Anything you say could be used against you. Even casual remarks might contradict your testimony or reveal your strategy. The golden rule is discuss your case only with your lawyer. Avoid social media posts, public comments, or casual conversations about ongoing proceedings, especially before the trial. If you want to tell a story, tell it after your case is finished. Mistake number 10, thinking winning means everything. Even if you win, you might face appeals, enforcement challenges, or unrecovered costs. Sometimes a win on paper isn't a win in real life. The goal isn't just to win, it's to resolve the dispute in a way that serves your broader interests. Ask yourself, what are your broader interests? It could be your control in the business, your reputation, your peace in mind. More often, it's the elimination of risks to enable yourself to invest your resources somewhere else and move forward. So keep perspective. Sometimes a smart settlement or partial victory is far more valuable than a bloody fight in trial. Conclusion. Litigation is complex, but avoiding these 10 mistakes can make the process far smoother and more successful. Now let's recap. Be clear about your goals, plan your budget, be honest with your lawyer, stay open to compromise, commit time and effort, meet deadlines, be patient, respect the process, keep your case confidential, and remember, winning isn't everything. And as always, consult a qualified lawyer about your specific situation. Thanks for watching. See you next time.